Hello, I'm Ari Melber in for Karen Finney today, and you're watching Disrupt.
Eric Holder has now joined the fight to restore the section of the Voting Rights Act that the Supreme Court struck down.
Fierce reaction today to Attorney General Eric Holder's plan to target Texas.
I might not be here as president had it not been for the Voting Rights Act.
They're trying to deny Texas our sovereign rights.
This is the department's first action, but it will not be our last.
North Carolina's legislature passed a law requiring a government-issued photo ID.
Being called the most draconian voter suppression effort in the country.
We act as if racial profiling is not an issue.
Anytime there's interracial crime, there's an overwhelming chance that the victim is going to be white and that the criminal is going to be black.
When I was in Illinois, I passed racial profiling legislation.
Michigan Governor Rick Snyder to put Detroit through bankruptcy.
Signs of decay and neglect are everywhere.
Federal bailout off the table.
I think Detroit's going to have to work with its creditors on this.
We've got a lot to get to today, including how to save Detroit and how to end racial profiling in America. But we begin with a major development in voting rights this week. Attorney General Eric Holder is taking Texas to court. That move drew swift partisan reactions. Republicans protested, Democrats rejoiced. But to see the big picture here, it helps to go beyond today's politics. You have to look at an intense battle over civil rights laws in the courts. A battle that played out off stage and off camera over the past several years. Long before John Roberts was in charge of the Supreme Court, he was working in the trenches of the conservative legal movement. As a Justice Department attorney in the early 80s, he advocated against the Voting Rights Act and argued that its supervision of voting to protect against discrimination was, quote, the most intrusive interference imaginable by federal courts into state and local processes. Now think about that. That put Roberts to the right of the Reagan Revolution. After all, it was President Reagan who signed a reauthorization of that very interference in 1982. Years later, Roberts took his agenda onto the court, where he has slowly, incrementally, but relentlessly knocked down key civil rights protections. In fact, in a little noticed 2007 opinion, he limited how schools can use diversity to integrate classrooms. That opinion also laid down a false premise that conservatives have been embracing. The idea that programs which use race to level the playing field are as legally objectionable as the Jim Crow rules that were used to oppress people on the basis of race. Complaining, for example, that school segregation was, in a very real sense, equal to the very diversity programs that we use today. Roberts wrote that, quote, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Now let's fast forward to this term. Roberts applied similar logic to affirmative action, where he was actually on the losing side, and then, of course, the Voting Rights Act. The voting ruling basically knocked down two parts of the law, Sections 4 and 5, you probably heard about. And those sections used to create a list of local governments that would actually have to be cleared in advance before they could change any electoral rules. Now, those parts are dead unless Congress updates them. The rest of the law, however, remains intact, and that's important. That includes sections that allow the courts to add a similar kind of supervision for local governments. The remaining part of the law is less strict. So instead of using that list of discriminatory areas, the DOJ has to ask courts to add new local governments that are discriminating, one at a time. So, if the Attorney General sees discrimination in, say, Alabama or North Carolina, he can just ask the courts to add that state to this list for extra voter supervision. North Carolina, as you know, is currently pushing the harshest voting crackdown in the country. So, they may be asking for some time in the penalty box. And that leads us to the question this week. Why did the Attorney General start with Texas? Well, I would argue it's because Holder knows that the courts have already found evidence of discrimination there. Here, for example, is a ruling from 3 federal judges last year, and that includes a George W. Bush appointee. They found, quote, the voter ID rule imposed strict, unforgiving burdens on the poor and racial minorities in Texas are disproportionately likely to live in poverty. 5 other states on that supervision list have already moved on new voter ID laws since the court's decision last month. And in a new interview, and I thought this was pretty interesting, liberal Justice Ruth Bader Ginsburg said that these measures, the ones we're talking about in those states, are precisely why we as a country still need the Voting Rights Act. That is the context for the Attorney General's new effort this week, because with or without Congress, he's just getting started.
The Department's first action to protect voting rights following the Shelby County decision, but it will not be our last. Even as Congress considers updates to the Voting Rights Act in light of the court's ruling, we plan, in the meantime, to fully utilize the law's remaining sections to ensure that the voting rights of all American citizens are protected.
All right, let's bring in our guest, co-director of the Advancement Project, Judith Browne Dianis, and Matt Miller, a former aide to Attorney General Eric Holder. Matt, I want to get right to you. What exactly is the Attorney General doing, and where do we go from here? Is it just Texas?
No, I don't think it is at all. I think he's sending a clear signal that although the main tools that the Justice Department has for enforcing the Voting Rights Act have been struck down by the court, they still do have some tools. And in the absence of Congress acting, and Congress does need to act, they're going to use what they have, and they're going to take aggressive action. And you saw them start with Texas. I think they started with Texas because there's a record here, as you indicated. They've already shown in court that Texas has a pattern of recently discriminating. But I don't think they'll end here. I think North Carolina is also likely to draw a challenge over their voter ID law. I think Texas also, which passed a discriminatory voter ID law several years ago, I think that's going to be the next challenge probably in the next several weeks.
Right, and he's picking up on something that was a sort of a conversation below the mainstream discussion here, where a lot of talk was about voter ID in the legislatures. I want to read to you something that a legal scholar wrote a couple years ago, basically saying that DOJ should use Section 3, use this part of the law we're talking about, as a shock that would push the courts to evaluate intentional discrimination and build evidence of ongoing unconstitutional state conduct that could justify the need for the law going forward. Is that basically what the Attorney General's decided here, that those civil rights advocates who said we need to use the rest of the law aggressively were on to something several years ago?
Yeah, that's absolutely right. I mean, one of the things you see, the Attorney General, when he announced this suit, said that in addition to bringing this suit, he has shifted the resources inside the Civil Rights Division so that they are now focusing on bringing suits under this remaining section and under other laws. And so I think you'll see a movement now going forward to do whatever they can under Section 3. Now, again, as you pointed out, Section 3 that does not have the same teeth that the parts the court struck down had. So the ability of the Justice Department to block discriminatory laws isn't what it used to be, but they can still do a lot, and hopefully Congress can come in and reinforce what's been struck down.
So Judith, walk us through how we get from what Eric Holder's doing here with the powers that he already has to this debate back in Congress, where a lot of people, including a couple Republicans, are saying we actually need to renew the law.
Right. Well, Section 3 is an underutilized part of the Voting Rights Act. So it's really important to know that, the Attorney General hasn't gone beyond the bounds of the law. He's actually doing his job. He's being aggressive and enforcing the law. But what we need is also the fix by Congress, because the thing that we lost with what the court did in the Shelby County case is that we lost a provision that allows us to stop discrimination before it happens, which is really important in the voting context, because, of course, an election can happen. The outcome could be something that it shouldn't have been, but for discrimination. And you can't go back and change that. Courts haven't decided, let's, unseat the incumbent because of the fact that there was discrimination. So we need that provision, and we're looking to Congress to fix it. But in the meantime, the Attorney General and civil rights organizations will enforce the provisions that we still have.
Right, and what you're talking about also has come up in criticism of Justice Roberts' opinion. I mean, in the criminal context for regular Americans, regular defendants, we hear about 3 strikes and you're out. We hear about your prior record being held against you. And really what the Voting Rights Act did was apply a similar record evidence to states and local governments, that if they continue to discriminate, if they continue to say that black people aren't going to have the same rights to get to the ballot box, that was going to be dealt with in advance and dealt with based on a history of discrimination. So I want to get your response on that point to a criticism from Judge Posner, who, of course, was a very prominent conservative judge who looked at this ruling that we got last month, which I think some of us are still digesting, and said the reasons Congress has for treating some states differently for purposes of the Voting Rights Act are not arbitrary because racial discrimination in voting continues. And rebutting the conservative argument made by Roberts, he says there's no doctrine of equal sovereignty. The opinion ultimately rests on air. That's pretty strong judge-on-judge criticism, if you will. What did you make of it?
Well, I mean, basically, I mean, we know that we do not have a country where we should have discrimination in voting. The Voting Rights Act is an important tool that, Judge Roberts, you started off talking about his history. Mm-hmm. Where did he come from? And this is why it's so important who gets nominated to the Supreme Court, because he came to the court with an agenda.
Exactly.
He came to the court with an agenda to undermine civil rights laws that are on the books, to undo what we have accomplished in this country. And so it's not just voting, it's affirmative action. We're going to see a fair housing case go up to the Supreme Court that may undo disparate impact, where we can use statistical evidence to show that discrimination occurs. And so it's really important to know where these nominees are coming from and what their agenda is. And unfortunately, in this case, they have the majority right now, but that's okay. We have a Department of Justice and civil rights groups that will continue to enforce the law. And I think Judge Posner is right that we can't allow a runaway Supreme Court to undermine the progress that we have made.
Yeah, well, you mentioned the housing context that we're going to see next term, where you have some conservatives saying we shouldn't even be able to use data on systemic racial discrimination to basically patrol racism under the Fair Housing Act, even though all the lower courts that have looked at it have said that's a good way to try to defend people. We will be keeping an eye on that. I want to go, Matt, to you with the last word here. A big part of this, and the reason why I think it's upset so many people, is the question of whether we are a functional democracy. You go to school and you learn about America as this great beacon of democracy, and we have so much to be proud of when you look at it historically in setting certain precedents. And yet at the same time, for most of our history, we were an apartheid democracy, and the Voting Rights Act tried to really change that. And so, Matt, as you look ahead on what the DOJ can do, even without Congress, if they don't act, what is your outlook here, and what should people take from the Attorney General's rather strong leadership this week?
I think they're going to use every tool they have, but they're limited. The best thing that they can get is if you look at places that have really a history of discrimination, like Texas, and I'm from Texas. It gives me it gives me great pain that we've now become the poster child for writing discrimination into the law, but that's what courts have found on several occasions. Mm-hmm. So if the department can get courts to put Texas back into the penalty box that you described in your setup, and if they can put other states back into the penalty box, in the absence of Congress acting, or if it takes several years for Congress to act, where there's a real pattern of discrimination and of recent discrimination. That's what's happened here. It's only in the last few years. Yeah, ongoing recent discrimination. If courts will give the department the tools to, again, review laws in advance so they can block them before elections and not after the damage has already been done, that's the best possible outcome we can hope for.
All right. We will keep an eye on that. I want to thank you both, Judith Browne Dianis and Matt Miller. Next up, from your right to vote to your right to walk down the street without being profiled or stopped or frisked, we have on the program a Democratic senator who says it's time for a national ban on racial profiling. That's up next.